I have Kpandai as the first.
Thank you. It's what is advertised.
Yeah.
Right.
So, see, as usual, I have my own views about Kpandai. They are not simple. They are not comfortable. But these are my views. I come to these views very slowly, observing for a long time, what is going on, and then I conclude. And when I conclude like that, I tell myself that I'm wrong, and then see how the facts will play out. And many times I've said things here, and they've just turned out to be true. This is the problem with Kpandai. You have two factions in a space, and each of them has a case. You listen to the Kusasi side, they are the Aborigines, they have a case. You listen to the Mamprose side, they have a case. Now, seeing that each of them has a case, none of them is prepared to yield. Peace requires compromise.
That's not Kpandai.
Sorry.
That's Boku.
I'm talking about sorry, I'm mixing those. Sorry, so let me not use the names.
Okay.
We are speaking about Kpandai.
Right.
Kpandai is the election rerun.
That's right.
Okay, sorry. I was speaking about the Mamprose thing.
Right.
But, okay, so incidentally, I was in court. And when Kpandai came up, we said some very simple things. What we said is, one, until the justices of the courts make a final pronouncement, nothing is final. And I went as far as saying, and I put it on Facebook, that an election is not won at the polling station. Speaking law, because the EC officers are officers of law. If they don't do their work according to law, it is all null and void. Led by Akoto Ampao, I and him went to court to have the processes set out, how you do this and that, patient. If you don't use that process, which is a legal process, the whole thing is off. I gave the analogy that, look, if you win an election by 10,000 votes, that is what happens at the polling station. If in a court it is shown that 5,000 of those votes were invalid, you did not win, the court will determine that your number is 5,000. So it is a court that finally will adjudicate whether you have won or not, unless the other party doesn't take it up. To that extent, the principle has been clear. That
the principle of election petitions is that, as you said, if the court impugns 5,000 of the votes, and those 5,000, if they were dashed to your opponent, will not change the results. They leave the sanctity of the vote.
Correct.
Don't touch it.
So that's the math. But the court decides what happens at the polling station is valid or not. So my point is, getting 10,000 votes at the polling station does not mean you have 10,000 votes. The court will decide what votes you have. We need, look, I started saying this from the first presidential petition, that as a country, we need to put in our minds that the justices are the supervisors of the realm. And it is what they say that is final. And I have said, and I repeat, this idea that you win elections at the polling station, much as there is some truth to it, it generates violence. What we must tell people is this: in a proper, lawful society, it should be possible for a person to go and vote and go home. In a proper, lawful society, it should be possible for persons involved in an election not to have observers. In a proper, lawful society, it should be possible for the citizens to trust the Electoral Commission so much that they don't mount whole armies, people don't snatch ballot boxes, and don't engage in all kinds of lawlessness to so-called protect their vote. If we did just that, then you will see a situation where the justices don't come in. But as long as we keep saying you win at the polling station or you lose at the polling station, etc., people do all kinds of things over there, and then the thing ends up in court. And please, when it ends in court, this is where Inusa and his people come in. When a matter is sub judice, it is not determined, do not take a step to overreach the court. Indeed, that is what the justices said. So, having had this problem
when it's a matter sub judice, you are talking about a judgment of the High Court in Tamale that has invalidated the election and made a clear order that let's have a rerun of the elections in 30 days.
Correct.
And that is what the processes have kicked in to, as it were, execute and implement. So
To the extent that that judgment is not challenged, it is the law. A bad ruling, what we lawyers call per incuriam, even if it is not in line with the law, as long as it is not challenged, it is the law, and you have to obey it. But immediately it is challenged, everybody must understand, it can change. To the extent that it can change, nobody should to a challenge. Everybody, including Parliament, should have taken notice that this can change, and therefore you have to organize yourself with that in mind. As far as I'm concerned, the EC also should be mindful that it is a creature of law, and between Parliament and the Supreme Court, the EC has to listen to the Supreme Court. In the first place, they are the cause of this problem.
The Supreme Court has not spoken until they gave the suspension.
When I say listen to them, I mean when
the clerk of Parliament operated on the basis of the Constitution and proceeded to issue the notice to the Electoral Commission declaring a vacancy. The law says once that notice has been issued, the processes, the EC must within 30 days ensure that the elections are done.
My point.
Are you saying the EC could have done otherwise?
I'm saying that the person who declared the vacancy made a mistake, which is why I'm saying Parliament should also listen to the Supreme Court or abide by the laws, appreciating that it is the justices that finally decide.
Tell us why the person made a mistake.
Because it says when a seat becomes vacant, and my humble submission is that as long as that challenge is extant, as long as that challenge is going on, it has not been declared ultimately, finally vacant yet. Because that vacancy will have to be declared by the Supreme Court or the courts before which it has been put. So, to the extent that there was a challenge, I think the proper thing should have been to hold our hands. And somebody will say, well, what if it never gets called and it doesn't get adjudicated in time? That is why we have to have our elections courts.
As a lawyer, you say that what you would tell your clients when they have been victorious in a court and there is no impediment in their way, regardless of an pendency of an appeal, which does not operate as a stay, to stop them from realizing the fruits of their victory in a judgment. They should
I'm saying the contrary. When there is an appeal, immediately an appeal is filed. Even that is not a stay.
Correct.
Okay, but we are talking about state institutions. We are talking about EC, Parliament and co, which have to respect each other and also appreciate that, look, what happened can happen. All of us were saying, don't do this because the Supreme Court can stop this thing, and they ended up stopping. So the point I'm making is, when you have an appeal, look, in private matters, conduct can be different. And can be, we are defending people or we are, pushing people's cases. We'll move forward. But in these constitutional matters, state issues, the proceedings of government and co, I think the attitude must be different. My point, and I repeat, I said it before the Supreme Court made a ruling, and I'm saying it now, is that when the matter went on appeal, that seat should not have been declared vacant, because an appeal can succeed.
You have been told about the mischief rule. So the state must take a step, but I want to scuttle that step. So I go to the court and file a process. There's no order, there's no judgment from the court. And you say the state must stop and wait until a decision has been
There are rules about the performance of constitutional duties and state duties. So where it hasn't risen to that fact, yes, the mischief rule, we all know it. But we have to make a distinction between the mischief rule and people's rights, which is why we repeat, we need to have our elections, petitions, courts. So if the person is within his rights, he has filed a proper appeal. Of course, he should go ahead and do the stay of execution or whatever it is.
Yes, they filed the appeal, filed for a stay of execution and proceeded with the certiorari application in the Supreme Court.
They should go ahead and do all those things. But I have been in the Supreme Court where we have filed a case which has been heard and dates have been set for ruling. And before the ruling came, the government proceeds to do exactly what the case is against. We file an injunction because the state calculated and breached what was there. We go there, and the Supreme Court justices are saying we should withdraw the injunction because it has been done. The state calculates to overreach the court and disrespect it. So we are saying people do these things. But when it comes to state issues, look, we have a situation where EC proceeds to go and do an election, spends money, starts mobilizing, then the Supreme Court comes and says, stop. It is our money that is being wasted. Yeah. That could have been foreseen. If they had just responded or respected some of the principles, this is not my mind, this is the law, we would have avoided all of this. What I'm saying is, look, mischief rule, all those things, let's clear them. But the right of a person to appeal...
Is it the Ayimensa, it's a gentleman represented by Afenyo King. Because of that single individual, the Supreme Court stopped the whole Judicial Assembly elections, and all the expenses that have been made went to waste.
And that is willful, loss. Somebody decides, I'm going to go ahead. The Supreme Court just makes a ruling and all that money is lost. And I'm like, couldn't you have foreseen this? If you didn't foresee it, we saw it, we said it. Okay, so look, going forward, we should stop these things. It's happening too much.
Professor Piejetia,